legal reasoning doesn't mean that the use of history in the proper disciplinary sense has a legitimate status that other forms, that other disciplines of understanding don't have either. So just to summarize that, it's to say, sure, legal reasoning uses the record of the past all the time, and that's fine. But to say that originalism has a legitimacy and authority because it is grounded in the use of history, I think the argument could just as well be said, well, let's use what we learn from sociology to enlighten legal reasoning. It's no more of a justification for originalism than, pardon? Yes, that's right. So there's no more originalism grounded in a reference to the discipline of history is no more legitimate than living constitutionalism, than living interpretation, with respect to the sort of to the use that's made of disciplines that fall outside the discipline of law. That's all I'm saying.
It seems to me that it depends on what the question is. That sociology is relevant when we're interested in facts about how things work. Economics is relevant sometimes, and even in constitutional interpretation when that matters. But history is relevant for a different set of issues.
The data is relevant, but the explanation is a different form.
Just one quick point about what Bob Borden is saying. In a way, we're still dealing with the problem of pre-modern, modern, but now postmodern, because the problem is that history, as a modernist enterprise that was going to discern historical truth, has displaced the pre-modern forensic history that everyone was comfortable with, that Reid talks about. And now I think the problem is we know that these historical narratives are constructed, but it's very difficult for the law to accept that we're arguing about which is the best narrative for our Supreme Court. But that's what they're arguing about.
So we are very close to the end, but still some patient people. So Parker?
Yes, I was trained as a historian and had a PhD before I went to law school. I practice, I don't profess. I was very refreshed, Professor Irving, by what you said about there being an epistemological difference. There is, because at the end of histories, we rarely read so ordered as we do at the end of a judicial opinion. But I wonder, and this comes from being a practitioner, I make historical arguments when I make arguments in court, and I make them in front of panels of judges, some who are better historians, some who are not better historians, and I get to judge that, of course, as the auditor before them. Some of the best historical arguments I've had is when the judges themselves take on the mantle